We will be dealing with the topic of compromise, amalgamation, merger, arrangement, compromise and arrangement. Section 230 talks about compromise and arrangement. 231 talks about power of tribunal to enforce compromise and arrangement. Then merger and amalgamation. Section 232 talks about merger and amalgamation. 233 talks about fast track merger. 234 talks about merger of Indian company and foreign company. Then shareholders who are dissenting means they are those who are not giving their assent to this compromise, amalgamation arrangement. They are dealt with 235, and minority shareholders are dealt under section 236. And then power of central government to amalgamation in public interest. Now, why these situations are required? We have already studied about reconstruction of the company, and there we studied internal reconstruction and provisions like reduction in share capital, buyback of share. Now these are external reconstructions of the company. So many times business of company is not happening properly due to management issues, due to deadlock, due to changing market, or many other things, or object of company is being frustrated because of some new laws. The company is not able to perform the functions as per its objective mentioned in memorandum of association. So whatever the reason is, the company requires reconstruction, and these instances incorporate external reconstruction of the company. Now how it happens? For example, A company is there. Now business and undertaking of this A company will be transferred to B. What will happen now? Either B will form for the purpose of reconstruction this will be a new company formed for the purpose of new construction. New object may be included. Owner substantially be same person who are interested in A. The managers, directors of A company will be there in B company. Same business that of A. So these may be situations. So what is happening? A company is now not A, but it is B company. Altogether new company is there. Either A may merge into B, or A is gone away now and B has come to the identity. Amalgamation. When two or more companies are joined to form a third entity, or one is observed or blended with another company. If A or B companies, they are being joined, and now we have a C company, or A company has been reconstructed and now we are having B company, then this is amalgamation. This was said in North of England Protecting and Indemnity Association 1929. Now form of reconstruction and amalgamation, how it can be done? By sale of shares as stated in Hari Krishna Lohia, by sale of undertaking, by sale and dissolution, by a scheme of arrangement. Here we are concerned with scheme of arrangement. Compromise, arrangement and amalgamation. Name of the chapter is compromise, arrangement and amalgamation. Section 230 talks about power to compromise or make arrangement with creditors and members. Clause 1 says, where a compromise or arrangement is proposed. If compromise or arrangement, it means people are agreeing to certain things, they are leaving certain things and they are accepting certain things. That's how this compromise and arrangement take place. Analogy can be created by when you go for this arbitration and conciliation and get the things done. So where a compromise or arrangement is proposed between B/W means between company and its creditor or any class of creditor, or between a company and its member or any class of member. So compromise or arrangement is proposed between company and creditors or between company and its members. If it is proposed, then tribunal may make order, tribunal by virtue of order may call a meeting, and this meeting will be held and conducted in such manner as tribunal direct. Now this order for meeting by the tribunal will be given when application is made to the tribunal either by company, creditor, member or liquidator in case of winding up. So if there is a compromise or arrangement is proposed between company and creditors have undergone some compromise arrangement for the purpose of reconstruction, or company and its members have been compromised or entered into certain arrangement for the purpose of reconstruction of the company, then any one of them will apply to the company, and company on that application will order a meeting, and it will be held and conducted in such manner as tribunal direct. Now arrangement includes reorganization of share capital as well. Reorganization of share capital can be done by consolidation of share of different classes. You will consolidate all of them, or you may divide the share into different classes, or by both of these means you can do arrangement. So arrangement includes reorganization of share capital. It can be done by two ways: by consolidation of share of different classes or by division of share into different classes. Either any one of these way may be used, or both of them will be used. This is how it is being done. Now as per clause 2, when application is there, then there will be an affidavit also by the entity who is making the application, and this affidavit will disclose material fact of the company like its financial condition, auditor's report. We have already done auditors and financial statement, accounts and auditors we have already done. Financial statement is also there. Now affidavit will disclose this, and reduction of share capital under the scheme. Scheme means this compromise and arrangement. Terms and conditions of compromise and arrangement will be scheme. Compromise, arrangement, amalgamation. There will be certain terms and conditions, and that will be scheme. How they are going to do it? Are they are reorganizing their share capital by both the means, by one of these means, and any other thing that will be considered as the scheme by virtue of which any of these transaction is being happening. So coming back to the point, reduction of share capital under the scheme of corporate debt, restructuring consented by not less than 75% of secured creditors. So scheme of corporate debt, restructuring consented by not less than 75% of secured creditors. When 75% of secured creditors will give consent, then it will happen. An affidavit will disclose that yes, it has happened. Now these 75% of secured creditors, they include creditors' responsibility statement. As the name suggests, they are self-explanatory. Safeguard for protection of creditors, both secured and unsecured. In this scheme, in this compromise, amalgamation or arrangement, what are the steps have been taken to secure the position of creditors? Then liquidators report that fund requirement after corporate debt reconstruction conform to liquidity test, meaning thereby CDR means corporate debt restructuring. After you reconstruct this corporate debt, after that you are having liquidity, meaning thereby you are not going insolvent. Your liability will match your capital. If not, that does not mean it is equal, but it means that company can sustain the debt and company is not going to get insolvent. Now company going for CDR as per RBI. So there may be provisions, there are provisions of corporate debt reconstruction as per Reserve Bank of India, and these guidelines may also be, and these are required to be followed. Then valuation report in respect of all asset. A valuation report will be there in respect of asset, which will be stating the condition, the amount, the it may also consider the future value, not specifically but tentatively or near future. Now, about this meeting, that is by the order of tribunal, clause 3 says notice to be sent to, and this notice will be accompanied with all creditors or class. So notice will be sent to all creditors and class, all member and debenture holders. Notice will be sent to all creditors, all members, debenture, all debenture holders, and it will be accompanied with statement disclosing detail of the company or detail of compromise or arrangement. Statement disclosing detail of compromise or arrangement. Copy of valuation report explaining the effect of compromise and arrangement on material interest of directors and debenture trustees. Means what would be the impact of the scheme on directors and debenture holders. It has to be mentioned in this notice. And by virtue of clause 6, if scheme is approved by majority representing 3/4 of creditor or member, if it has been approved by this majority and then approved by the tribunal through a order, it is binding, and this order shall provide all or any of the following, which will be covering on the in a minute. Now, this requirement is directory and not mandatory, meaning thereby, for example, all of these members have not been agreed. Few of them have agreed and tribunal find it to be relevant, then tribunal may release the order and it will be binding. So order shall provide all or any of the, these are the points A, B, okay, C, A, B, D, C, E. These are the points it will provide. If compromise and arrangement provides conversion of preference share into equity share, then preference shareholder shall be provided. If preference shares are being converted into equity share as per the scheme of this compromise or arrangement, then these preference shareholder, they shall be provided either to obtain arrears of dividend in cash. They can take their arrears of dividend in cash. Dividend is provided in arrear to preference shareholders, we have already done that, or accept equity share. They may accept equity share equal to the value of dividend. Either you take it the money in the cash, or you can take equity share of that value. Protection of any class of creditors. If compromise arrangement is agreed by creditors, then any proceeding before Board for Industrial and Financial Reconstruction established under Section 4 of Sikh Industries Company, Sikh Industrial Companies Act 1985, it shall abate. It will not be happening till the time this reconstruction or this compromise is being happening. Then if compromise and arrangement result in variation of shareholder right, then it will be given effect under Section 148. Such other matters as tribunal thinks fit, including exit offer to dissenting shareholder. The shareholders who are dissenting, they may exit. So these are the instances which will be there in the order of the tribunal, if tribunal fit, if tribunal thinks fit. Then by virtue of clause 10, it says no buyback of share to be allowed unless in accordance with Section 68. Section 148-68 we have done already. Now clause 11 talks compromise and arrangement may provide for takeover except for listed companies. In case of listed companies, this takeover will be done as per by the guidelines of SEBI, Security and Exchange Board of India. And apart from this, if any apart from the listed companies, takeover is happening for unlisted company, any person who is aggrieved may apply to tribunal. Now by virtue of Section 231, power of tribunal to enforce compromise and arrangement. 231 clause 1. Clause 1 says if tribunal sanction compromise and arrangement under 230, then it has the power. Okay, so by this order, notification and meeting, now tribunal has sanctioned the scheme. For this compromise and arrangement, we'll use the word scheme. We'll use these words synonymly. So tribunal has power to supervise the implementation of the scheme. Tribunal can supervise. Tribunal will be taking day to day or once in 2 days, as the case may be. Tribunal will be supervising the implementation, taking the report, how it is being happening, what is the progress made, and tribunal can give such directions as required for the purpose of this sanction and implementation. Clause 2 says if tribunal is satisfied, then scheme cannot be implemented. If tribunal is satisfied that scheme cannot be implemented satisfactorily, then it shall give order to wind up. Okay, so if scheme is not happening properly, then tribunal will ask for wind up, and it will be deemed to be a order under 273, which deals with winding up of the company. Look, reconstruction is done to save the company, as stated earlier. Reconstruction is done to save the company. Okay, if it is not being saved and state of affairs of companies are not happening properly, then it will be wind up, it will be dissolved. So in order to save the company reconstruction takes place. If reconstruction is not happening properly, then tribunal can go for winding up of the company. 232 talks about mergers and amalgamation of the company. If application under 230 shows to tribunal that scheme for compromise and arrangement provides for merger and amalgamation, and that under the scheme undertaking property liabilities of company is required to be transferred to another company or proposed to be divided among and transferred to 2 or more companies. So the same thing is happening which we discussed earlier. A company, okay, undertaking property liabilities of A company is being transferred to B company. So A company is gone and B company will be there. Or it is proposed to be divided among 2 or more companies. So property undertaking liabilities of A company may be divided between B, C and D, as the case may be. So after this application, tribunal may order a meeting. A tribunal will call, held and conduct the meeting. Now, as per clause 2, an order of tribunal concerned companies shall circulate on order of tribunal. When tribunal will issue this order, then concerned companies which are there in this amalgamation and merger scheme, they will circulate draft of proposed terms of scheme. What are the proposed scheme? They will circulate that draft, confirmation that copy of scheme filed with the registrar, that the copy of this scheme it has been filed with the ROC, and that report adopted by merging companies explaining its effect on each class of shareholder, key managerial personnel, promoters and non-promoters. So a report which will be adopted by the merging companies explaining its effect on, these will be tentative effects only, but they will not be superficial also. Experts reports on valuation, supplementary accounting statement. So once order is there, then on receiving the order of the tribunal, concerned companies shall circulate these points with each other within the company. Clause 3 says tribunal, after satisfaction that 232 clause 1 and 2 are complied with, then they will order. So once tribunal is satisfied that clause 1 and 2 has been complied with, then may order sanction of compromise or arrangement by subsequent order, making provision for the following matters. So after compliance of clause 1 and 2, tribunal will make provision for the following matters. Tribunal will transfer to the what are the provisions? Transfer to the transferee company of whole or part of undertaking property liabilities. Transfer to transferee. So transfer here means the company which is seeking for the merger or amalgamation, and transfer is the company in which this company is being merged or amalgamated. For example, A company requires reconstruction, then A is transfer, and B, C, D as the case may be are the transferee. So transfer of transferee company, transfer to the transferee company, whole or part of undertaking, property or liabilities as the case may be. Then allotment or appropriation by transferee company of share debenture policy. Obviously, when transferee company will be having hold over the transfer company, then there will be allotment and appropriation of share debenture policies and other instrument. Obviously, it is going to happen. Now, new company or the company in which transfer is being merged, they will be taking care of the things of A company, and A company will not be in existence, but their property and assets will be held by them. The continuation by or against of the transfer of any legal proceeding pending. Now, legal proceeding for A company is pending, so it will keep on going, it will be continued, and it will be taken care of by the B, C, D as the case may be. Then dissolution without winding up of transfer company. Now, once transfer company is not existing, it means dissolution. Dissolution means ending of the company. Company is coming to an end. Dissolution can be done by winding up and by other means like merger, amalgamation, by similar means. So dissolution by without winding up. Now, provisions to be made for any person for which tribunal directs who dissent from the compromise of the arrangement. Dissenting shareholders may be also covering under this, may also be covered under this provision. Now, if share capital is held by non-resident shareholders under FDI, foreign direct investment norms, then the allotment of share of the transferee company to such shareholder shall be in the manner specified in the order. Transfer of employees of the transfer company to transferee company. Now, employees who are working in A company, what will happen to them? They will be transferred to B, C, D as the case may be. So, order of tribunal will provide for these provisions. Where transfer company is listed company and transferee company is unlisted company. Where transfer company is listed company and transferee company is unlisted company, then just by virtue of merger or amalgamation, this unlisted company will not become listed. Okay, so such the transferee company shall remain unlisted only. So amalgamation or merger does not make this unlisted company listed one. And if shareholder of transfer company decide to opt out of the transferee company, so shareholder of A company, they decide to opt out of B, C, D as the case may be, then it can be done, and order will provide for the same. Where the transfer company is dissolved, so by virtue of merger amalgamation, A company will not be there, its identity will be gone, then fee if paid by transfer company on its authorized share capital, meaning thereby whatever the liabilities of the transfer company, whatever the liabilities of A company, that will be taken care of by transferee company. Okay, it will be set off against any fee payable by the transferee company on authorized capital subsequent to amalgamation. So scheme will provide for this, order will also provide for this. It will be decided that obviously liability will go to transferee company, and how it has to be decided. Now, such incidental consequences and supplementary matters which are deemed necessary, meaning thereby which are inherent in such transactions and activities. So after tribunal is satisfied that subsection 1 and 2 have been complied, by a subsequent order they will make provision for the matters. 233. Merger or amalgamation of certain companies. 233. Clause 1. Scheme of merger and amalgamation may be entered into between two or more small companies, holding company and its wholly owned subsidiary company, or such other class of company as may be prescribed. And such merger of amalgamation is subject to the following. First, inviting objection or suggestion from registrar, official liquidator, or person affected by the scheme. So when merger and amalgamation is being entered in between any of these entities, then objection or suggestions will be invited from registrar, official liquidator, or person affected by the scheme. If they are having any objection or suggestion, they will place it. Then objection or suggestion considered in general meeting and approved by a member holding at least 90% of total share. So objection and suggestions which are considered in general meeting and approved also. Then companies involved in merger to file declaration of solvency. So such merger and amalgamation will be subject to these conditions. They will file declaration of their solvency, that they are not going to bankrupt or they are not at the stage of bankruptcy. Clause 2 says transferee company to file a copy of scheme so approved with the registrar, central government and official liquidator. So transferee company will file copy of this scheme which has been approved between transferor and transferee with the registrar, central government and official liquidator. Clause 3 says on receipt of such scheme, if registrar and official liquidator has no objection, then central government shall register the same and issue a confirmation. But if there is any objection, then by virtue of clause 4, that objection will be communicated to central government within 30 days. Now, as per clause 5, regarding this objection, on receiving this objection, or central government think that scheme is not fit in public interest. Okay, so 235 clause covers that on receiving such objection, and apart from that, independently, if central government thinks that scheme is not fit in public interest, or it may get this notion by virtue of this objection only, or is there conjunctively, not distinctively, then central government to file application before tribunal within 60 days. And in this application, they will apply to the tribunal, and if tribunal is satisfied, tribunal will approve the scheme and confirm this. And it has to be shared with the concerned registrar as per 233 clause 7. Now registration of scheme as per clause 3 or 7, it is deemed to have effect of dissolution of transfer company without winding up. So transfer company is being dissolved, transfer company, that is A company has come to an end, life of A's company has come to an end without winding up. Now A has become B, C, D as the case may be. Now effect of registration as talked earlier: transfer of property or liability, charges on property, legal proceeding, by or against, amount unpaid to settlement of dissenting shareholder. This will be transferred from transfer company to transferee company. Now we'll take B as transferee company. 234, merger or amalgamation of company with foreign company. Now 230 to 240, to apply to the scheme of merger and amalgamation between companies registered under this act or registered in other jurisdiction as notified by central government. Now central government in consultation with Reserve Bank of India may make rule for merger and amalgamation, and rules are there. A foreign company with the approval of RBI may merge into company registered under this act, and company registered under Companies Act with the approval of RBI may merge with foreign company. Now demerger, scheme of subdivision of enterprise into smaller units or splitting up of units into separate units. So merger also covers demerger. Scheme of amalgamation may also include demerger, when one company is being split into other smaller units. 235 talks about power to acquire share of dissenting shareholders. Now if scheme is approved, then within 4 months B company, transferee, B company within 2 months sent notice to dissenting shareholder for acquisition of their share. Now shareholders who are not accepting it, so obviously they will be exit, and they are having shareholders. What will happen to their share? So their share will be acquired by the B company. Now as per clause 2, unless an application made to tribunal by dissenting shareholders, or if any application is made but it has been disposed of in favor of B company, then B is bound to acquire share within 1 month of said notice. And as per clause 3, after notice and application to tribunal being disposed of, this B company would pay the amount or consideration as the case may be. So B company would pay amount or consideration, and after that B company will get itself registered as holder of such share, and within 1 month of such registration, dissenting shareholders are to be informed that it has been done, and now they are the registered holder of such shares. After this process, here tribunal has been provided with very wide discretionary power. Next is purchase of minority shareholder, shareholding, not shareholder, purchase of minority shareholding. Section 235 gives wide discretion to tribunal for allowing or disallowing the sanction. Now, two guiding principles are there. First, scheme should be fair, and onus lies on dissenter that scheme is unfair. It was held in Horwell and Company Limited, 1933. Now, purchase of minority shareholding. 236 clause 1 says, the acquirer company, B company in the case, shall notify its intention to purchase minority share, that is remaining shares. And clause 2 says, and acquirer shall, after a determined amount, acquirer shall offer a determined amount as per valuation report. So based on the valuation report, they will offer a determined amount, and they will notify their intention first, and then they will offer the amount. The minority shareholder may offer to majority shareholder to buy their shares by virtue of clause 3. Now minority shareholders, they are not bound. They are not bound that the acquirer company is offering. They may offer their share to be taken by majority shareholder. If this is happening, then transfer company shall act as agent in the deal. Okay, so the transfer company, a company, will be acting as agent between minority shareholder and majority shareholder to get the deal done by virtue of clause 5. If majority shareholder fails to purchase the minority share, this section would apply to residual minority shareholder. Okay, for example, if these majority shareholders, they fail to purchase all the minority shares, then for remaining, this section will apply. Now 237 talks about amalgamation in public interest by central government. Clause 1 empowers central government. It says, if central government is satisfied that amalgamation of 2 or more companies is essential in public interest, then as per clause 3, every member of transfer company shall have same rights and interest in the transferee company as he had in transfer company. For example, what it means to say, if a person is having certain right in A company, okay, that is transfer company, then he will be having similar rights in transferee company, that is B company. If these rights and interests are not similar, then compensation would be awarded. Now central government to share draft proposal to company concerned regarding the scheme and for receiving suggestions and objection. If any appeal to tribunal is made by aggrieved person as to amount of compensation and then appeal is disposed of, then relevant changes have been done in light of suggestion and objection. So central government will share the draft proposal to receive the suggestion and objection. If any appeal to tribunal is there as to compensation, that has to be disposed of. After that, if any suggestion or objection have been received, then relevant changes in light of such suggestion and objection, and after satisfying this, these requirements have been done, an order can be made under this section. 273 clause 6 says copies of such order would be placed before each house of parliament. So this is all about compromise, arrangement and amalgamation.